All right, next on the docket, we're going to take a look at a couple cases that'll kick off discussions from everything from board defendants to lack of witnesses. And let's start off with that indifferent defendant. In the case, it's accused Boston Marathon bomber, Mr. Sarnarev. Now, as the Times reporter in the courtroom says, during most of the proceedings, he either slouches in his chair like a bored student, picking at his goatee, or his mind is completely somewhere else here. So, Susan, I'll start with you. As it relates to body language of a defendant, what do you coach your clients with the do's and don'ts when they're sitting there in the courtroom? We see some people furiously writing notes on notepads. We see some people, focusing right on the witness and the testimony. Others head down, some looking at the jury. What do you counsel them to avoid, and also, if they want to communicate how they should?
Well, one of the I find myself constantly pinching the client to sit up or not to slouch, but you like any actor, you want your client to communicate to the jury that he or she is a human being who deserves their sympathy, who deserves their concern, who doesn't laugh or smirk at the testimony of witnesses. And that's a big problem, that if the client is hearing testimony that he truly disagrees with, he starts to make faces or even say things, and that's bad. That's
not helpful.
That's not helpful. But the other thing, I mean, in a perfect world, for a criminal defendant, he would have another attorney or a paralegal sitting next to him, engaging him constantly, talking to him, showing the jury that he relates to another person and that he's concerned about his case. I don't think that there's that kind of defense team in this case.
Literally, Jimmy, there were the heart-wrenching stories of the final moments of lives of some of the victims that died, and including one where there was just about no dry eyes, with the exception, obviously, of the defendant here about that 8-year-old, and just what happened when that pipe bomb that he and his brother had set went off in his final moments. And apparently he looked listless and laid back and everything else. If this is your client, do you grab him by the arm during this and say, sit up here? Do you tell him to take notes? I mean, sometimes, it's easy to say, but there's 10 hours, they're hearing testimony forever, and you're talking about a 20 or younger guy. What do you do? I'm sure you've had situations where the worst thing going for you is your own client, right?
He's looking at the death penalty. His case is being tried to save his life, not to have him found not guilty.
Yep.
And so that jury is looking at him throughout this trial, during this heart-wrenching testimony, trying to figure out if he's got a soul. And so it's so important for him in a case like this to be affected, if he's affected. It just may be that he's not.
I'm imagining myself in that jury box, and I'm hearing and I'm looking to take out that pain that poor kid and his family is enduring, and I'm looking at this twerp there, sitting there like he's got someplace better to be. Whatever I feel
but
about
that's
it,
what you're going to be saying.
Exactly.
That's what you're going to be saying when you're deliberating on the death penalty. People are going to be looking back and thinking about stuff like
Rich,
that.
as a lawyer, you have to know your client. If the trial is more than 2 days long, they're going to revert to who they are. So that may be sometimes something you have to address in jury selection, to say, listen, I don't know how somebody acts innocent or looks innocent, or if your guy is a creep and shifty and looks around, you may have to say that to a jury, because ultimately they're looking at him like he's an exhibit at the trial. And that goes for families.
Let's stay with the jury thing, and let's go to another high-profile case, the Aaron Hernandez case. And I'm going to be the jury here while you guys are the attorneys, because it struck me, and I got to imagine people in a jury pool, the lack of witnesses that the defense team for Aaron Hernandez, and for those who don't remember, he's the former New England Patriots player who was pled not guilty to murder of Orden Lloyd 2 years ago. Even though this is high profile, it looks like there's going to be a single witness that they're going to call. And Doug, I understand the argument. If it's not going to help, don't bring on additional people that can be subject to cross. I get all that. But is there a concern as an attorney that you're sending a message to the jury that you can only find one guy, a DNA expert, who's willing to speak on this guy's behalf?
Well, if you're going to have one good person, it's better than 5 bad people. So this is a young man that he's a professional football player. He's at bars. He probably has a crazy life. If you bring in a lot of his community, they could probably say some things that people wouldn't take the right way. So one good witness is better than 5 bad.
But you know the optics of this to the jury, Mayo, which is you couldn't find somebody to speak to this guy's character?
He had somebody who spoke to his character, and that person wasn't called by his team. That was the owner of the Patriots, who basically spoke
He
very
testified
favorably for him.
for the-
And so, in summation, you can argue that, number one, bring home again the charge that the judge gave all of these jurors before they were selected as jurors, that, you know, the defendant has no obligation to do anything. He can fall asleep at that table, and so can his lawyers if he chooses. And if you're going to call a witness, presumably there's a reason they're calling a DNA expert. If that DNA expert comes in and is able to refute the physical evidence, you know, then that's going to be huge. If he's able to say, hey, listen, you know, these weapons are not tied to my client. There's no physical evidence linking my client to these crimes. And then you have just a positive of the owner in his interaction with Mr. Hernandez, then, you know, you're much better off. It's much smarter than putting on somebody else. Sometimes even if you put that other person on and they don't hurt you, if they're not helping you, they end up hurting you.
But if I'm sitting in that jury, Susan, I've heard from the victims' families about the life that was lost here. I'm hearing from this guy's wife, who didn't exactly paint the rosiest picture. She didn't say he did it, but certainly it wasn't a ringing endorsement of Aaron Hernandez. And I go up and down the line. Then it comes to, yeah, you know what? Can't say without a definitive doubt that we don't have a murder weapon. That much we don't know. And I can't give beyond a reasonable doubt that all those fibers were his. They're human beings in the jury pool, and they're going back and saying, everything I hear about this guy's a bad guy. I can't beyond the 100% thing, no, he did it, but you know what? If I have to go with a toss-up, I'm putting this guy away. Is the calculation when you're picking who you're going to put up that you got to humanize him a little bit?
You're saying put up as a jury,
No,
as a witness?
If you're the defense team, do you have to try to humanize him just a little bit?
You do. You absolutely do. And you do that throughout the entire case. You do that from your opening statement, from your cross-examination of the witnesses, and there's going to be an enormous number of opportunities to do that.
But you're the paid
because-
mouthpiece, and the
Yes.
jury knows that. Your job is to try and get him off no matter what. I'm not hearing from anybody else who told me, you know what, I know this guy, he could never do that. I've seen him, yeah, he's got a temper, but never once did I ever see him with a gun. I've known him for 20-something years, look at all the good things he did, whatever else. I didn't hear any of that about this guy.
Well, you would only be able to hear that through a character witness.
Yeah.
And a character witness can only testify to the defendant's reputation in the community. So they can't say, you know what, I've lived next door to him for 10 years and he takes my garbage out and he always checks in on me and he's the sweetest, nicest person. They can only testify about reputation in the community. And that's not always
You've
possible.
had some interesting clients over the years here. Have you done the same defense that they did? Bring one medical guy and then basically say I rest?
You know, you have to also understand, you're my jury, so I have to remind you that the burden is on the people, and throughout this case, we have shot down every one of their witnesses. We don't have to put witnesses on when we have created a reasonable doubt, and he is entitled to the presumption of innocence. So I'm not, ladies and gentlemen of the jury, going to just put witnesses up for the sake of putting witnesses up, because you're going to do your job. He's a human being. He's entitled to the presumption of innocence. They haven't proven their case. So why would I waste your time just putting witnesses up there? You want me to humanize him? Look, he's human. And throughout this trial, I'm talking to him. You see, he's got, you know, I'm touching him, and he's responding to me, and he's, you know, so that's the answer to that question. But you have to address it.
You're human, Doug. You're not an animal.
Thank you.
Dog is human. Listen, let's put that on the record.
It's so established. All right, when we come back, I'm very curious what the table's going to say about this one. I'm not sure this is what the Founding Fathers had in mind when they created the Constitution, First Amendment rights here, but a group of California prostitutes are suing the state saying that their First Amendment rights are being violated because it's illegal for them to practice their trade. We'll be right back.